Okay, welcome to Chapter 10. This is pretty far into our course here. We're going to be wrapping up a lot of the aspects of the trial system, the courtroom, and soon we'll be moving on to the corrections before we have a couple catch-all chapters at the end. So this is really the last emphasis, or one of the last emphasis that we're going to see on some constitutional issues in regards to trials, but that will carry over some of these constitutional questions really to the next few chapters as well when we start talking about corrections, because the Constitution also applies, of course, to the correctional system and inmates. Obviously, some questions to ask before we really start. You've probably heard from the time you were very young that if you're arrested for a crime, that you have a presumption of innocence. Now that's a statement, but I think it's fair that you should think about evaluating that statement. Do you really have a presumption of innocence? If just ask yourself this outside of the courtroom system. If you see someone on TV being arrested and put in a squad car, do you say, well, we got to presume he didn't do it? I really don't think people start from that perspective. And of course, we should ask, should this presumption of innocence exist? What does it do? The next major question I think that you should be asking as you review a lot of the material in this chapter is evidence, and should all of it be brought in? The way I like to frame this at first is ignorance of any fact or opinion more helpful in making the right decision? So by not telling someone something, does it make their making the right decision easy? And if so, why? Don't we make our best decisions with all the possible informations? The last one's a little bit controversial. I threw it in there to try to stimulate you thinking about things outside of the box. You've certainly heard of wrongful convictions, where you have people that serve 5, 10, 20, sometimes longer years in prison for crimes that it is determined they didn't commit. Well, people put them there. Those people were the prosecutors, the judge who were running those trials, the juror, and the defense attorneys. So my question to you here to ask before you start and think about is, yes, you want to make amends to the person who was wrongfully incarcerated all those years, but what about the people that put them there? So, if someone's the victim of a crime, yes, you want to help them, but you also want to punish the people that made the mistake, even if it's not an intentional mistake. We do put people in jail for acts of negligence. So should prosecutors or judges or jurors that sit on a jury, or defense attorneys that failed to win their client's acquittal, should they be punished criminally? Should they be fined civilly? What role should that be? All right, just something to ponder as we go through all this. Let's move on to the speedy trial. Like I said, we're going to hit some of the different parts of the Constitution that we've only touched on a little bit. Certainly we'll talk about the Sixth Amendment a little bit. We'll hit the Fifth and some others. So the Sixth Amendment, at least in part, it's got a few other sections to it, says, to quote after a comma, "The accused shall enjoy the right to a speedy and public trial." Now, there has been no codification of this at the federal level. So in North Carolina, we do have a statutory right to a speedy trial, and that's North Carolina General Statutes 15-10. But having said that, like much of the Constitution, you have these relatively simple words that you think you could easily define: speedy, public. But what do those mean? Does that mean that you have to have one as fast as possible? Do you have to have one without any delay, with some reasonable delay? What is a reasonable delay? So delays are very, very common. Typically, delays can arise because the defense makes a motion to wait on the trial, or the prosecution says, well, we have to wait on the trial. But also there's an issue, I'm reminded, of public trials. You may or may not have been paying attention recently, and I'm recording this in September of 2021, but there are the preliminary motions of trials down in Guantanamo Bay. These are American trials, so presumptively there is some right to a speedy and public trial here, but these aren't public trials. These are trials that are being done without the public having access to them. So when we say public trial, does that mean everybody gets to get in it? Does the victim have a right to be there? Does the prosecutor? So, or defense attorneys, or when? It's not uncommon for serious felonies to take a year or more to go to trial. It'd be certainly possible in Wake County, North Carolina at this time, for someone to be arrested for a serious felony and not have a trial for, I would say, up to 2 years. Certainly up to a year would be a very common period of time, and you could argue that's not a speedy trial. All right, so I said we'd move on to another amendment. Now we're going to talk about the Fifth Amendment, self-incrimination. Again, the Fifth Amendment has some other parts, but it says, at least in part, no person, here's the key, shall be compelled in any criminal case, so remember this doesn't apply in civil cases, to be a witness against themselves. Now we typically will call this taking the fifth. You refuse to answer any question that may show guilt of a criminal act or a crime. Now, this places some interesting limits. One of the first things it does is if an individual decides he's not going to testify at trial, I'm sure many prosecutors would like to say, and logic might lead us to believe, well, if he's innocent, he should take the stand and tell us the story. But the prosecutor is not allowed to argue that the failure to testify means he's admitting to a guilty act. I think in part because there can be things that you want to keep secret from a jury. You don't want to testify to them because it might make you look bad, but be unrelated to the trial. A couple things here. I put one down, but there's another thing because I want to emphasize criminal here, is if you are granted immunity, if the prosecution says I'm going to give you immunity to this charge, then you lose the right to not disclose information. Also, if it's just a civil matter, if you're just being sued civilly, and if there is no pending criminal prosecution, you can be compelled to answer questions. Now, the other thing, I'll give you a quick example here of how that worked just recently. Quite famously, Bill Cosby, who certainly when I was growing up was kind of America's dad with the Bill Cosby Show, has been accused of raping numerous women by drugging them and then raping them. He was only convicted of one. In part, this is a statute of limitations problem, but the appeal on that led to him being let out of prison. And I get the question frequently, well, how did this happen? And to simplify it, although it is more complex than this, a prosecutor told Bill Cosby that he would not prosecute him. In other words, he granted him immunity if he disclosed information. Now, Cosby disclosed certain information as part of it. Some of this was part of civil, and that information was later used against him at his criminal trial. Well, that's a clear violation of self-incrimination, essentially. So that was an error of law, and the trial was overturned, and his sentencing was overturned, and he was let out. Presumption of innocence. Now, it doesn't say in the Constitution. There's not the 58th Amendment or something that says you have a presumption of innocence. It is a theory or an ideal that underlies the American system, that we presume that someone on trial is innocent of what they are charged with. Now, I'll say that's a presumption. I would say, in fact, the opposite seems to be true. I think that most people, if they look in a courtroom and they see someone sitting there, in worst case scenario, say they're sitting there in orange fatigues at, say, Department of Correction, and they're chained, and there are bailiffs standing next to them, the presumption is, wow, this guy must have done something bad. He must be guilty of something. The other thing, and again, this is not a constitutional issue so much, is how much evidence do you need? So it's not just any evidence. I mean, you can produce some evidence for ridiculous things, you have to show proof beyond a reasonable doubt that the defendant committed the crime. So you have to present to a jury or a judge, if it's a bench trial, that this individual committed this act, and I can show that beyond a reasonable doubt. Now, it is not any doubt. There's doubts about lots of things in the world that are true. Again, in theory, this is a high standard, but as this bias exists for the prosecution, it's not that difficult to meet. And I think this is at least in part why we do have innocent people being convicted. Because although we say you've got this high standard and people will present evidence, sometimes juries just don't apply this. Sometimes, to be honest about it, judges just don't apply this. Well, I mentioned the juries, and again, we are at a constitutional right here. Now, this constitutional right exists both in North Carolina's Constitution and the federal Constitution, the Sixth Amendment. Although recently we kind of changed the North Carolina Constitution to allow people to waive jury trials more easily. The Sixth Amendment of the Constitution guarantees you the right to a jury in a criminal trial. Now, that's not every trial. Obviously, if you've got a speeding ticket, you're not getting a jury trial. It's pretty much, and this is an exaggeration, it's pretty much, is it a serious felony? Are you in danger of being incarcerated? Even a misdemeanor where you could serve time in jail triggers certain rights. But are you going to jail? You got a right to a jury trial a lot of the time. However, not every criminal trial is a jury there. Often someone will waive a jury. In which case we call those trials bench trials, because the only one sitting, the man on the bench, is the judge. So in regular trials, the judge determines issues of law. He rules on motions of law. And the jury determines the facts. Is there enough evidence beyond a reasonable doubt to convict? If the jury's not there, the judge wears both those hats. Okay, where do we get jurors? Well, we're going to introduce a little Latin here, venire. V-E-N-I-R-E. Venire is a list of all possible jurors. Now, what North Carolina does is it takes all the registered voters and pretty much everybody with driver's license. And different states will use a few different things to mix in there, and that becomes a list. And then every so often, the clerk of that county will send out a jury summons to people on that list saying, okay, we're calling X number of jurors, we need you to come in. Now, in the past, this was a mechanism of discrimination. At first, at the very beginning of the American Republic, the only people sitting on jurors were property members. First of all, you had to be a man. You had to be over a certain age, although that wasn't necessarily as explicit. So you had to be a man, and you had to own property. Sometimes the property levels were pretty high. And what that did is it gave you a relatively small body of people that would sit on juries. Gradually that changed. We widened it up. We let more people sit on jury. One of the first things that kind of fell was the idea of property requirements. We started to say, well, all people should have the right to sit on a jury. And then what fell was gender. One of the last things to fall, and this didn't fall in some ways and still is an issue today, is race. In the past, not just here in the South, but in places like Indiana and Illinois, Boston, for goodness sakes, Hispanics were excluded from jurors. So currently, what do you have to be to get on a jury? Well, these qualifications are fine. You don't get on a jury if you're not a U.S. citizen. You can't be on a jury if you have a felony conviction. If you're not healthy enough to go through it. If you can't read, write, and understand English. Those are the basic requirements. You can see they're pretty basic. Now, typically, decisions from juries must be unanimous, although a couple states allow, at least in non-capital cases, death penalty cases, they're going to allow majority or supermajority votes like 9-3. Having talked about this composition, you do need to be aware that sometimes this doesn't happen like we would like. And that brings up voir dire. I know it's spelled V-O-I-R-D-I-R-E. Sometimes you'll hear it voir dire, voir dire, It doesn't matter. It's just bad Latin. You can pronounce it how you like. It literally means to speak the truth. But what it is when both sides, the prosecution and the defense, interview prospective jurors from the venire and decide if they're going to get on the jury. Now, for both of them, both the prosecution and the defense, if they, when they're questioning the jury, they find out that someone is prejudiced for or against the defendant or has a connection to the case, you will challenge them for cause and they don't sit on the jury. So, for example, you call someone, you say, do you know the defendant? And he says, yeah, he's my brother. Okay, you can't sit on the jury. Hey, do you know the defendant? Yeah, he ran over my dog last week. Yeah, you can't sit on the jury either. The second group, and this is where we get into a little bit of problem, is preemptory challenges. Each side, the prosecution and the defense, gets a number, and this is going to vary from jurisdiction and seriousness of trial, and but let's just say 6. When you interview a jury, you can strike off those 6 people you don't like. Now, this can be directly because you think they're not going to vote the way I want. The prosecution might say, no, this person is going to be sympathetic to the defendant. I don't want him on the jury. And the defense might think, no, this person is going to be prejudiced against my guy, or is going to be pro-prosecution. I don't want him on the jury. So that's a preemptory challenge. And you're allowed a limited number of those. You don't have to state your reason. Now, here's where we get a problem. Prosecutors historically have excluded jurors because of race, ethnicity, or gender. They're not allowed to do this anymore. However, simply because, let's suppose you have, in the sort of classic case, you have a black defendant and you have an all-white jury. And the reason you have an all-white jury is that the prosecutor preemptorily challenged the 4 blacks who were going to be on the jury. Now you might say, well, that's prejudice, a violation of Voir Dire. You can't do that. Well, we don't assume that. The burden is on the defense to prove that that was racially motivated. So it is not uncommon at all, even in areas where minorities, the overall minorities, are the majority population, that juries are not reflective of that. So again, the burden is on the defense to prove that the prosecution acted improperly. We don't assume just, okay, the prosecution acted improperly. And that can lead to some issues. I was reading a case recently where an African-American male arrested in, I believe it was Alabama. He's had 4 trials, and in all 4 trials, the prosecution has been accused, and there's been sufficient evidence to overturn the 4 convictions, of packing the jury of racial discrimination. All right, so the prosecution cannot use preemptory challenges to seat all-white juries. Neither can you stack the jury with men or women to gain a favorable verdict, but clearly these abuse cases continue to exist. And you can read the case of Batson versus Kentucky. It's a United States Supreme Court case. And in that, there is a 4-part test that is established, but it really hasn't had the impact, I think, that the court might like it to have had. All right, moving on. The trial. Now, I think in part because we've seen a lot of TV and motion pictures, the trial is very often the center climax of the movie because this is where the 2 sides are going to fight. And that's reasonable, but trials in many ways are not as dramatic as you see on TV. First and foremost, most trials are won or lost before they even start. Trials are about the presenting of evidence. Trials are about the presenting of witnesses. If you can keep certain witnesses out, or if you can get certain evidence in, that's going to shape the trial. So evidence being excluded or admitted, witnesses being testified or not being testified, or what they can testify about, this is all shaped before the trial starts by motions. Motions are simply requests to the court that the court rules and says this is admissible or this is not admissible. So often you make a motion to suppress evidence, saying, well, this evidence was gathered improperly, they tortured my client for a confession. Or you dismiss someone from testifying because they are incompetent. You say, okay, this person is a meth addict who claimed that he just saw aliens 5 minutes before he's claiming that he saw my client stick up the liquor store. You also might want to restrict evidence or witnesses. They can only testify about this, not about that. All right, the first part of a trial is the opening statement. Basically, you tell the jury, most of the time, the judge, if it's only a judge, if it's a bench trial, you tell them what they're going to hear. And this usually gives you a broad outline of what each side's theory of case is, how they're going to either prove guilt if they're the prosecution or establish innocence or maintain innocence. So the defense can argue that their client is innocent, or you can simply say prosecution hasn't proved guilt. So remember, the burden is on the prosecution to prove something. I don't, as a defense attorney, have to prove anything. If I can show that the prosecution didn't prove guilt, then that presumption should kick in and my client should go free. That's a theoretical standard. All right, evidence at trial. Not all evidence is admissible. There are three big gatekeepers of evidence. All evidence must be relevant, all evidence must be material, all evidence must be competent. So relevant means it must impact the case in some ways. Let's suppose that someone on trial for robbing a bank was also a wife beater. And the prosecution says, well, I want to admit evidence that he beat his wife. Now, why would the prosecution do that? Because if you're arguing in front of a jury and you've got a misogynist as a defendant, someone who beats women or is abusive towards women, and there's women on that jury, you would think, and I think it would be a logical assumption, that that will impact how they'll look at that person and they might be more likely to convict. But you notice that has no impact on whether he robbed the bank. So it wouldn't be relevant. Now, material means it's important. So let's suppose that you rob a bank and you get $1 million. And the prosecution says, I want to admit the serial numbers for each and every $100 bill. Well, how are you going to do that? I'm going to read them out in court, each one at a time. Okay, $100. That's 10 for 1,000. That's 100 for 10,000. That's 1,000 for 100,000. That's 10,000 you're going to have to read out. That would just be not a material issue. The judge might say, well, if you've got money that you found on the part of the defendant and you can show that those 5 or 6 bills were taken from that, let's just provide a sample. Let's keep it material. Let's not go to trivial. Let's not go to every one. The final one is competent. Can you trust it? You know, if someone says, well, yes, I was wearing my X-ray visions and I saw into the house and I saw Fred shoot Barney. Well, nobody has X-ray vision, so I would be pretty doubtful that really occurred. It wouldn't be a trustworthy. You might be able to rule that that person was incompetent to testify. So there are clear rules for the admission of evidence, but those are the big three: relevant, material, and competent. Most evidence will fall into two broad categories. Is it testimony coming from a witness, or is it a physical object, real evidence being admitted? Now, even real evidence, though, has to usually be guided in, unless there's a motion to accept it, by a witness. So, types of evidence. Again, and this applies to both witnesses and physical evidence, there's direct evidence. So let's suppose a witness said, I walked in the room, I saw Fred take out a gun and shoot Barney in the face and kill him. You now have direct evidence that Fred killed Barney. Circumstantial evidence is evidence that doesn't directly show something, but indirectly shows it. And often this needs some sort of corroboration. I heard 3 shots, I walked in the room, Fred was standing over Barney, the gun was smoking. Well, you have circumstantial evidence that Fred shot Barney. And you can corroborate this. Yeah, we did an autopsy. There were 3 bullets in it. We swabbed Fred's hands. There was gunpowder residue on it. So Fred fired a gun. The bullets were in Barney. We're going to establish the murder. There's also prejudicial evidence. Now, this is evidence that is in, or shouldn't be in most of the time, that is usually excluded because all it does is inflame the jury. It appeals to emotion. It doesn't prove anything. And this is a frequent area where people fight, defense and prosecution, because You may want to get favorable motion evidence in, and I might want to keep it out. And sometimes it's just unrelated to the trial. All right, the prosecutor's case. The prosecutor has to establish what we call the corpus delicti. He has to show that each and every element of the crime was committed. So if we took the crime of first-degree burglary in North Carolina, you broke, you entered, and occupied dwelling at night with intent to commit felony and or larceny therein. So there's 7 or 8 elements there. If the prosecution doesn't establish each one of those elements, if they introduce no evidence that the crime occurred at night, that charge fails. So you have to say, okay, officer, when did you show up? 11 p.m. That's night. You're done. You've got enough evidence that a jury could say, oh, it happened at night. What did you investigate? It was a person's house. That's a dwelling. Okay. Was it the defendant's house? No. That's another element. You broke, you entered, and occupied dwelling of another at night. Did you find anything? Yes, the door was broken open. I saw muddy footprints that led into the house, so someone broke, someone entered. I saw that a TV had been stolen. I saw where it ripped out. I caught the defendant a half a mile away running with a TV underneath his arm. Typically, the prosecution here will offer direct testimony from witnesses. They'll call a witness, and basically they will say, tell us what relevant, competent material evidence you have about this crime. It's basically tell me a story. They're not supposed to engage in leading questions. They're not supposed to testify. Now, trust me, the prosecution has talked to every one of those witnesses, and that's perfectly okay. Everybody does that, and has gotten that story, and has heard that story. So they know what that person's going to say. That's why I often tell students that trials are much like plays, where everybody has lines and everybody knows what those lines are. Now, the defense has the right to cross-examine. And this is a confrontation clause of the Sixth Amendment of the Constitution of the United States. You have the right to cross-examine to show that there was an error or a falsehood. So let's talk a little bit about more cross-examination. I love a good ghost story. I love a good story about UFOs. Fascinating, great story. I love it. Let's hear it. I'll even listen to stories about Bigfoot and Chupacabra and the whole 9 yards. However, when someone tells you a fantastical story, as much as it's good, I saw a mermaid, I was down there, and they came out of the water, and, they shook my hand, and they said, yeah, I'm King Triton or something. I'm just making something up, folks. What's critical there is to be able to ask a few questions, because anybody can tell a good story. But if you said, okay, what time of year was it? Where were you? Were you drinking? Were you doing drugs? How tall was this? Why did it speak English? How did it speak English? Did it have gills? The problem with a lie is you have to invent the reality around it. And unless you're very, very good, you're not going to be able to create a real world around a lie. You're not going to be able to prove that you saw Bigfoot. First of all, because Bigfoot doesn't exist. But second of all, because all the things that could have possibly happened that I could ask about, you're not going to know because you're lying. Now, one of the issues of cross-examination is hearsay. Hearsay is an out-of-court statement being repeated by a witness. So he heard something, and very often this is coming from the defendant. I heard the defendant say this. So what I usually do in class is I write out these words. I didn't say she was the one who stole my money. And I ask you what that meant. And you can see that if I'm repeating on the stands, I didn't say she was the one who stole my money. Now I've got no inflection on any part of that sentence. So it changes, notice, if what the defendant really said was, I didn't say she was the one who stole my money. That would intimate that there was somebody else. Or if the defendant had said, I didn't say she was the one who stole my money, that intimates that she did steal something, but she didn't steal money. Now, if the person repeating it doesn't place the right emphasis, even if they remember the exact words, which they probably won't, you can see how it would be garbled. So hearsay is theoretically admissible. However, there are 24 exceptions to the hearsay rule, which really means that more often than not, hearsay does get admitted in a courtroom. All right, the defendant's case. In theory, as a defense attorney, I do not have to offer a case. Practically, though, I have to create reasonable doubt. I have to poke holes in the prosecution's case, expose a lie, expose a mistake. Now, there are other things I can do. I might have a great alibi for my defendant. Oh, you claim that my guy robbed the Piggly Wiggly on December 1st, 2020 at 12 noon. Okay, I have a receipt from Harrah's Casino in Las Vegas where he cashed a check, and here's the videotape of him doing it. Here's his alibi. He couldn't have been in both places at the same time. That's a great defense. Self-defense. Yeah, my guy shot, but he shot because your guy was shooting at him. Insanity, and I've talked about insanity before, but basically my guy has a mental illness that renders him incapable of understanding right from wrong. Duress. He was under immediate physical compulsion to commit the crime, or entrapment. The police led him to commit the crime. Those are other possible defenses you might raise. All right, after the defense has put its case on, sometimes there's a rebuttal, which means the prosecution answers some of what the defense did, and then a surrebuttal where the defense calls witnesses to challenge the rebuttal. You don't see that a lot, but it could happen. The last major thing before it goes to the jury or the judge is closing arguments. Each side, and the defense has to go first here, which is too bad. We have to go first. We stand up and we argue that they didn't prove it, that my guy is innocent because they haven't proved beyond a reasonable doubt he committed the crime, or that my alibi is good. Each side focuses on what they are hoping is the strong points of their case and attack the weak points of the other side's case. And then you argue this in front of the judge and the jury. Now, okay, let's assume there's a jury. After it's done, if there's a jury, the judge gives them jury instructions. Ladies and gentlemen, jury, here is what you need to consider. Here are the elements of burglary. Here is what must be proven beyond a reasonable doubt. You should consider this and this, but you may not consider these and these facts. So then the jury then leaves the room, and typically there's 12, and they deliberate. What goes on in the jury's mind is anybody's guess. There's been lots of studies and analysis, and we are just going to assume that 12 people together have a type of collective wisdom that enables them to show that a crime was or was not committed beyond a reasonable doubt. Verdicts are only supposed to be based on evidence that's admitted in court and basic common sense. You're not supposed to say, well, I read this article in the newspaper that said this, or I read a blog that said that and said that he really killed her or something. You're not supposed to bring in that other stuff that wasn't in the courtroom. The jury then comes back and says guilty, he did do it, or not guilty, he did not do it. If they can't get it, suppose they had to have a unanimous jury like North Carolina, if 3 of the people say nope, not guilty, or 9 people say not guilty and 3 say guilty, that's what we call a hung jury. The jury comes back, they says, we can't read a verdict, Your Honor. And often the judge will set them back and give them some more instructions, tell them to try again. But if they can't, then we have a mistrial. And if there's been a mistrial, we can have a whole nother trial. So the hung jury, it's pretty rare. Only about 6% of cases does the jury not able to come back. So 94%, 95% of the time, jury comes back with a decision. That is the only time where you're really going to have a retrial because there's not been a verdict. Now I want to talk a little bit about jury lawlessness and jury nullification. Way back in the 1600s or so, there were some pretty bad laws. And some of them were attacked certain religions, and some of them attacked any criticism of the king. And at one point, some of these juries would hear these cases, and they would say, the law is really bad. The law is clear. The defendant had committed a criminal act, but we're not going to impose the law. We're going to ignore the facts, we're going to ignore the law, and we're going to find him not guilty. So you are nullifying the law. Now this, fast forward to today, We've seen some examples of that with drug laws. There are some jurisdictions where if you impanel a jury and you say, okay, I want to convict this person of possession of marijuana and give him 3 years in prison, people go back to the jury room and say, well, that's just friggin' nuts. I'm not going to do it. I don't care if you caught him with dope on him. I'm not going to convict. That's nullification. So here's a couple of interesting things. First of all, neither side can tell you about it. Neither the prosecution nor the defense can tell a jury they have the power of nullification. The other, and this is kind of, you might say, well, this sounds like a good idea. This is really putting justice in the hands of individuals. And I would agree that at least that part of it might be. But this can have an ugly side, because a jury also could say, yeah, I know there's no evidence to show that this defendant did it, but let's just pick a theoretical, a Martian, okay? So a Martian is on trial. And the people in the jury room go back and they say, well, Martians. You can't trust them. Every Martian I've ever met's a thief. They're no damn good. I know there's no evidence, but he probably did something, so let's convict him. So jury nullification can go the other way, is what I'm telling you. You can go where a jury lets off a guilty person, or where a jury puts someone in prison who's innocent of that particular charge. All right, and appeal. People think, oh my gosh, appeals happen all the time. They don't. Most appeals are not successful. And I spelled successful wrong again. I'll fix it on my notes later. Appeals can come from trials or other appeals. So if an individual is convicted at trial and he's happy with the verdict and happy with the sentence, the prosecution can't appeal and the defense doesn't. If the individual is convicted, the only person who can appeal the conviction is the defense. When you appeal, you often file a writ, which is you're asking for an order, a writ of habeas corpus. You're saying there's been an error of law. You go to a higher court and you say, look this over and fix it because they got it wrong. Well, having said that, if you lose at one level of appeal, both sides can appeal. So at first it's somewhat limited, pretty much just the defense, but after you've appealed once or twice, either side can keep appealing. Now this mishmash is the trial and the appeal process in North Carolina. So this is the North Carolina criminal justice process, and you can see how, all right, you got the crime observed and whether there's intervention, and go all the way up to the Supreme Court with affirmed or not affirmed. You can see it's a pretty complex process. Now, simple things like speeding tickets, it's not that complex. Murder could very well be this complex. All these things could possibly come into play. All right, I'd mentioned this just briefly, and this is another one of those constitutional rights. This, again, is in the Fifth Amendment coming up, and that is double jeopardy. Double jeopardy says, at least, and this is the Fifth Amendment, says at least in part, no one shall, nor shall any person be subject for the same offense to be tried twice, put in jeopardy of life or limb. So, you have a trial. The defense is found not guilty. Then evidence is clearly discovered that he did it. You're done. You can't have another trial. So I'll give you a somewhat comedic example. And this is might be an apocryphal story, but it's a good illustration. There's a very famous trial attorney in Texas, and one of his first cases, he was defending a man accused of killing his wife. And it's a Texas jury, and if you get a conviction in Texas for murder, death penalty is certainly a big option. So the defendant did not take the stand. He took his Fifth Amendment rights. The attorney managed to win the case for him. He was found not guilty. And he looked over to his client and said, that jury just saved you, a possible death penalty. You should stand up and thank them. And his client said, you're right. And he stood up and he looked at the jury and said, ladies and gentlemen, jury, thank you very much. I promise I'll never do it again. He essentially admitted that he did kill his wife. Well, you cannot retry him because double jeopardy is attached. However, if the defendant is convicted and appeals, he is waiving his double jeopardy rights, because you may get another trial and he can't say, well, no, you can't try me twice. No, you weren't happy with the first one. We're going to give you another one. You waive double jeopardy. Also, if no verdict is reached, if it is a hung jury, then your you can have trials again. All right. Now, I had intimated before that there are wrongful convictions. What happens when a factually innocent person is convicted of crime? Now, based on DNA alone, assuming that analyzing all those cases where DNA is present and there's been a conviction that was unlawful, about 12%. So 88% of the time we get it right, 12% of the time we get it wrong. These are wrong. So what's happening? Why is this system that we've created so painstakingly over centuries getting it wrong? Well, here are some of the issues. Misidentification. People seeing things they didn't see. Identifying people incorrectly. You know, sometimes you'll hear people say these words, well, they all look alike to me. And that can be people talking about different races, different cultures, different genders. People are just poor at identification. And it could be like, oh, when I said they all look alike with me, talk about cars, right? So suppose the defendant was driving a late model SUV. Would you be able to recognize the difference between a Ford SUV, a Toyota SUV, a Kia SUV, and get it right? Bad forensic science is the next one. Sometimes we get the science wrong. Sometimes we do the test wrong. Sometimes we don't use. For a long time, evidence was being admitted to identify certain bullets found at the scene of the crime based upon gunpowder composition. And the FBI had done a lot of studies, and they had kind of come to the conclusion that you could identify bullets that were produced in a lot. So in other words, if you bought a box of bullets, the gunpowder would be unique enough in that box that you could tell that a bullet came from that box. Turned out you can't. But for a while there, it was being admitted. Police misconduct. And this could be things like they tortured somebody, they broke into someone's house, they did something illegal. False confessions. Sometimes people will confess. It's particularly true with juveniles. Because, you know, one of the things that can happen is the police are allowed in an interrogation to lie to you. They can say something like, it'll go easier on you if you confess, which is not true at all. Or, we have other evidence that you did it. If you confess now, it'll look good for a jury. Well, that may be true, but they might not have other evidence. So people may confess now in hopes of getting a lighter sentence or believing that they're going to go home when, if they're a juvenile, they're not. False informants. There can be a solicitation to get people to lie on the stand by the state. What can happen is you can have someone who exercises his Miranda rights, says, I'm not going to talk to you. He's placed in a jail cell. In the jail cell next to him is an individual who's arrested for another crime, usually more minor. So you have someone you think kidnapped somebody. The police put a guy who was arrested for burglary in the jail cell next to him, and they say, hey, if the guy that we think committed this kidnapping tells you he did it, and if you testify against him, we'll drop the charges against you or we'll lower the charges. Well, that's a solicitation very often for false information. And of course, then you got prosecutorial misconduct, where the prosecution just lies or withholds evidence or packs the jury. So there are lots of reasons why we get wrongful conviction. All right. Well, on that note, not the most cheerful note, but again, I brought it in right around 45 minutes or so, which is where I like it. And when you're ready, we'll move on to Chapter 11.